Hi, y'all, and welcome to tonight's live stream. Well, if you had the privilege of watching the Karen Reed closing arguments today, you saw some of the finest closing arguments I have ever seen. For the first time, it really felt like a real face off. The defense was so confident, so bold. Alan Jackson was absolutely amazing. He laid out his theory clearly with a lot of force. The Commonwealth came back swinging. It was a great final closing argument by Hank Brennan, although he felt much more like he was on the defensive. That's how it seemed to me. It was a true shift in tone, and we will see whether that matters. Because I think out in the real world here, not inside the courtroom, inside the jury, I think a lot of minds are made up. And this case has been deeply polarizing. And there is pretty much no fact, no argument, no most brilliant closing argument of all time was going to change the way people on the outside who have been watching this case feel about it. But we are no longer the people who matter. And now the question is not what Twitter thinks. It's not what Reddit thinks. It's not what YouTube thinks. It's not even what we think here. It is only what this jury heard and how they are processing it. So today's closings gave the jury that final roadmap. The defense says there is no way that Karen Reed's car, her SUV, hit John O'Keefe. There is no way she killed her boyfriend and left him to die in the snow. The prosecution says there's no other explanation. That's what happened. Both sides claim that science is on their side. Both say common sense is on their side. So let's break it all down clearly, calmly, as honestly as we can, asking not what do we think with our view of which side is winning in our minds, but what did the jury hear? And what might they be thinking as they head into deliberations? So let's get into it. A special shout out to the first five in today's chat: KCAM4, Audrey, City Kitty 1, K&J Mom, and Gen X. Thank you all for being here. And I did a poll today on YouTube in a post, and I thought I'd share with you what the results were. I pulled this out shortly before, so let's go ahead and add that to the stage. So here was my question, and I'll make this a little bigger. I said, how long do you think it will take for the Karen Reed jury to come back? And about 15% of you thought today. Now, there may be a little bit going on there with people having answered it late since I pulled it out. And we already know the jury didn't decide today. We've already found that out. They went home for the day, and they will be back on Monday. So 45% thought Monday. And I will say I checked it throughout, and it was running pretty heavily for Monday or for several days. It wasn't, unlike the Lori Vallow Daybell trial where everybody thought, oh, it's going to be pretty quick. No, it was, most of y'all thought it would take a little time. So 45% Monday, 33% thought it would take several days, and 7% think that the retrial may be a hung jury just like the first trial. So I thought that was really interesting. I personally was going to vote for today. I mean, I didn't vote in the poll, but I just put it up. But I would have voted for today. So again, I am always thinking it's going to be really fast, and I am usually wrong on that. So I would have gotten that wrong, but most of y'all got it right. It's going to take longer than that. So we'll talk a little bit more about what the jury is going to think is important. I'm going to be doing another poll asking you about that. In fact, we could just go ahead and do that. While I'm talking, I'll go ahead and try to put that up, knowing that I'm unable to do that. I'm kind of a, think of one thing at a time kind of a person. All right. So, but I am going to try to get over there to open up a poll, because I'm curious what you think is the important issue in the case. Like, what is really going to grab the jury in this case? So give me a little time to get over there. And there we go. I'm where I need to be to start the poll. So here's what I'm going to ask you. Okay, I'm going to put in what do you think is going to matter most to the jury? Okay, let's see. What do you think? All caps. Mama Pinks will say I'm shouting. What do you think will matter to the jury? And then let's see, what should some of our choices be? I wrote out some of it here. One of the huge issues is the clips of Karen, which the prosecution, the Commonwealth, used very well. For the defense, I think the defense experts were a shining light for them. And witnesses at the scene, in other words, the people who say that Karen Reed said, I hit him, or something similar. So that would be pro Commonwealth. And truthfully, what all you're answering here is what are they going to be? What's the issue? So you might think they don't believe the witnesses at the scene, but you may think that's the most important issue. And the last would be poor investigation. One of the defense arguments was, this investigation was just terrible. So, okay, well, let's see what y'all think about that as we move on into our live stream. I have a lot of clips to show you from the closing arguments. I wanted to show everything. I mean, I go through, I'm like, oh, that's so good. I want to include this. Oh, that's really good too. So I cut and I still have a total of about 20 minutes, I think. So let's just start with an overview of, let me pull that out and I can just talk to y'all. Oh, I got to remove that. Okay. So I thought that the closing argument by Alan Jackson was one of the finest pieces of legal work I've ever seen. It was just brilliant. He actually read a lot of it, which often you hear, you shouldn't do that. You should just speak to the jury. But it was really, really well done. Brennan's was also excellent. I just put Alan Jackson in the totally brilliant category, but I also thought Brennan was fantastic. So let's start with the clip. And I tell you what I thought was so good about this. He started his closing argument with the exact thing he started his opening statement with. I thought it was so effective. Let me see. Says this one is
no collision. There was no collision. There was no collision. Folks, are the last line of defense. The last line of defense between an innocent woman and a system that has tried to break her, that falsely accused her, that tried mightily to bury the truth. This case was corrupted from the start. It was corrupted by biases and conflicts and personal loyalties that you heard about. And most fatally, it was corrupted by a lead investigator whose misconduct infected every single part of this case from the top to the bottom. The law provides.
So, let me stop for just a minute and talk about, I have it on 1.25 speed so I can fit a little more in. So if it seems a little fast, that will kind of explain why. So the focus of the last trial, I would say, was on the third-party culprits, on the conspiracy. And remember, before we got started on this trial, I said it's critically important that they try a different case. You can't go in and try the exact same case because the other side knows that case and it just won't work. They did a very different case this time around. They relied much more on experts, on testing, on science, and here, he focused in not just on third-party culprits of conspiracy. He focused in on what a lot of people talked about last time wasn't maybe emphasized enough, and that's just the straight-up standard. What does the Commonwealth have to prove? And what they have to prove is that the Commonwealth has established she is guilty beyond a reasonable doubt, and in this state, to a moral certainty. So I thought it was really well done, and we're going to hear a little bit of that focus on reasonable doubt. Now, the conspiracy isn't gone. Let me be clear on that. It's just more muted than last time. It just wasn't quite as inside the case. It was there, but it was more subtle. I forgot to ask this. Would y'all mind hitting the like button? That'll really help us bring more people in to join us. And if you are not subscribed yet, we would love to have you subscribe. Just hit the button. It's completely free. We'd love to have you back.
Beyond a reasonable doubt and to a moral certainty. That means at the end of this case, at the end of the trial, you think about one or more of the charges, you think, You know what? Maybe that's true. It might be true. Then you vote not guilty. If you think it's possibly true or probably true, your vote must be not guilty. If someone among you thinks it's likely true or even very likely to be true, your vote is not guilty.
Now, I want to say that is defining exactly what reasonable doubt is. Oh, lawyers, judges, we put words to it. We say, oh, this is what it means, but that's almost indefinable. You can tell people, oh, it's reasonable doubt. It's very certain. His use of leading right up to it, I think, is going to be really effective with the jury because it's just a set of words and it's really hard to define. And he takes the high ground, claiming as much as possible right up to the line. I thought that was really interesting and really well done. So he went into all of the things because his focus was on the investigation and the fact that the investigation just didn't do a lot of things you might expect it to do. Like, for example, the troopers never went into 34 Fairview. They never looked around inside. They didn't bother to get the ring camera video from across the street from a police officer's house. And they didn't call Trooper Proctor in the trial. The Commonwealth did not.
The lead investigator in a murder trial was never called to testify. Think about that. That should stop you in your tracks. Wouldn't you want to hear from Michael Proctor? Wouldn't you want to hear from the lead investigator in the case? Don't you have questions? The Commonwealth did not present their own lead investigator to the jury. The shirts.
So let's stop right there. I did a quick cut there, so I have to stop and explain it. So Proctor wasn't there, and the defense used that very effectively to sort of pivot over to, and that's the reason you need to discount the evidence he claimed to get. Look at Proctor. He's been fired. He was fired for what he did and said about Karen Read specifically. What he did and said related to this case, not just anything. That's why he was fired. And so if he's so untrustworthy, he even made the comment at one point, if they don't trust him enough to keep him, why should you trust him? And so he's going to say, look, that's a reason. The fact that Proctor is the one who supposedly gathered this evidence, that in and of itself is enough to discount and ignore the evidence.
The shards. Remember that when Mr. Brennan gets up and gets his closing argument. The shirts, the shards, all in Michael Proctor's possession. Mr. Brennan and the Commonwealth, I think, have pinned their hopes on some microscopic pieces of, or close to microscopic pieces of plastic that were claimed to have been scraped from the hoodie several months after the fact. What he failed to ask every single witness is who had access to that shirt and who had access to those taillight fragments, and the answer is it was Michael Proctor. Not for days, not for weeks, for months on end, for months unaccounted for, before they were submitted to the crime lab, before they were ever scraped.
And that is inexplicable. Why? Why didn't he turn that in? Why wait? Why do such a poor investigation? Now, the suggestion was not just about the taillight pieces, but also that Proctor planted other critical pieces of evidence that the Commonwealth is relying on. For example, what Jackson called the magic hair that clung for 37 miles to the back of Karen Read's car in the middle of a blizzard while it was driving at 47 miles an hour and was still there waiting to be just waving. In fact, he mentioned waving in a video when somebody went to test the vehicle. And then there was also the glass on the bumper. To me, this was some of the most important evidence that they had related to Proctor. The glass on the bumper didn't match anything that it should have matched at the scene. It didn't match the either bar glass or glass from inside the house, depending on your view, that John O'Keefe had been holding. It did not match the taillight, which had no glass. All that this glass matched, the only thing the glass found on the bumper matched was a random piece of glass that Proctor himself found at the scene. So here's what he said about that.
Christina Hanley, the quiet, reserved criminalist who told you something the Commonwealth likely did not want revealed because it's devastating to their case. absolutely devastating. And it's this. The glass on the bumper didn't match the cocktail glass. None of it. Remember, February 11th, Michael Proctor, without any other person with him, no witness, no supervisor, no other person with him, claims to have found a single piece of glass at the scene. February 11th, single piece of glass, Michael Proctor. Keep that in mind. Interestingly, the glass on the bumper that didn't match the cocktail glass, one piece did match one other thing, the Proctor glass. Those two go together.
Now, Alan Jackson said, look, Karen Read wasn't drunk. Data shows that from the black box of her vehicle that she was driving safely. She was stopping when she should stop. She was doing things appropriately. And other people who saw her said she was acting normally. She didn't appear intoxicated. She didn't appear unable to function. The cop, and then he went into the description of what Proctor had said about the cop and how the cop would be treated and how the cop would not get in trouble. In fact, that he told some of his friends, they said, I guess the people in the house are going to be in trouble. And he said, oh no, that was a Boston cop. And so the argument the defense is making is the way the people at 34 Fairview got treated is really different from how any of us would be treated in a similar situation.
What if it wasn't the house of a Boston cop? What if it wasn't the house of Brian Albert? We can be certain that investigators would have torn that house apart to get answers about why a fellow police officer was laying dead on the homeowner's lawn. You can betcha. But because this was Brian Albert's house, a Boston cop, nope. And because he was a fellow cop, an insider, they didn't even open the door. That is not justice, folks. That's just pure favoritism. Jennifer McCabe.
Now, and now we're going to segue into Jennifer McCabe, who was important in this trial, but nowhere near as important as she was at the first trial. One of the important factors they pointed out was that at 5:07 in the morning, Jennifer McCabe called her sister. Now, all that's happened so far is that Karen Read has called and said that John O'Keefe is missing. Jennifer calls Nicole, her sister, who lives at 34 Fairview, and the phone is live for 38 seconds. But Jennifer says, we never talked. Here's the argument that the defense made on that.
McCabe's phone records tell a different story, and they tell the truth. She spoke with him for the better part of a minute, 38 seconds to be detailed about it, at 5:07 a.m. And then she lied about that call. Remember that? What was the reason for that call at 5:07? Was it panic? Was it a warning?
So as I said, the conspiracy was a lot more muted this time. For example, do you remember last time at the end of the trial, everybody was talking about the butt dials and everyone was arguing about whether that was possible or not possible. Was that a crazy theory? Who could possibly butt dial back and forth several times? How does that even happen? But we don't even have that concept in this trial. That's not even there. Neither Brian Albert, nor Brian Higgins testified. And while Brian Higgins' messages back and forth with Karen Read came in, that whole issue did not. And so there is kind of a missing piece here that we know, but that the jury won't know. Jennifer McCabe, but getting back to Jennifer McCabe, her hostage to dying cold search was critical in the first trial and was again this trial. Here's what Alan Jackson said about it.
Why delete it? If the 2:27 a.m. timestamp is not true, why create a false story about Karen screaming Google hypothermia? That's just a fabrication. That's just a made-up fact. And by the way, if someone does tell you Google hypothermia, why would you Google how long it takes to die in cold? Wouldn't you just Google hypothermia?
Alan Jackson was particularly affected with practical arguments like that. There is also a place where the Commonwealth did that really well in the closing. Hank Brennan did really well also. Now, Carrie Roberts acknowledged during the trial that she actually did not hear Karen Reed tell Jennifer McCabe, would you please Google how long to die in cold or hypothermia? She had said earlier that she heard that, but she acknowledged at trial she had not heard that.
Carrie Roberts admitted that she perjured herself to back up Jennifer McCabe's false story. That was a dramatic moment in court. It's an admission of perjury, and you don't see that very often in a courtroom. That tells you everything you need to know about the character and quality of the prosecution's case and their witnesses, lying and perjury and admitting to it.
And of course, the ever critical point, did Karen Reed say, I hit him, I hit him, I hit him, or did I hit him? Could I have hit him? And the defense is saying, okay, maybe she said, could I have hit him, or asked, did I hit him? And here is the defense explanation.
It was.
Give it just a second. Yeah, give it just a
It wasn't a
second.
confession. It was confusion. And Dr. Russell explained that confusion. She told you why Karen Reed or anybody in that position might ask those questions. She was suffering from extreme grief reaction, which according to the evidence can last for years. Even her medical records confirm that diagnosis.
Now, Jennifer McCabe, when they got to the house that morning, she was driving with Carrie Roberts and with Karen Reed. When the three of them arrived at the house that morning in Carrie's car, they find a dead body on the front lawn. And Alan Jackson asked the pretty practical question, if you were to find a dead body on your sister's front lawn and you're calling her over and over and she's not answering, then wouldn't you go in to check on her just to see if she's okay? And it was those sort of very practical things that had not been addressed at trial that will be, I think, very persuasive with the jury as they make a final decision. And as I said, the Commonwealth had some too. You know, Brian Higgins was a central figure in the third-party culprit issue in the last trial. He was still in this case, but not as important. They did reference his, whatever it would be called, sort of romantic something with Karen Reed, and his trip to the station. Now, in advance, we've been told about the new evidence they would have of Brian Higgins at the station, at the police station on the night of the event. And it ended up being, I think, less important than some of the other new evidence that the defense submitted. Here is what Alan Jackson said about it.
Know that the CPD would be the first to get the call when someone reported John missing or injured. He would know what to look for, what to listen for, to determine if a report had been made and when and what the response was going to be. You saw the skulking through the hallways with his hood up, moving bags between cars, and of course, that late night mysterious phone call on his cell phone, a phone that you don't have and that you'll never see. All of that, and Michael Proctor never gave him a second look.
So one of the things I thought was kind of important about the Brian Higgins thing that did not come out at trial, probably because he didn't testify. But you may remember in the last trial, he explained the reason he went back over to the station was because he was moving cars. A blizzard was coming in and he needed to move cars around. I guess I wasn't really clear what, but do something. He was going to move the cars themselves in order to protect them from the blizzard. Well, we saw the video of him in the parking lot and he's not moving cars. He does go to several different cars and seems to be like taking his things out of one car and putting them in another, but he isn't driving cars around. Now, since he didn't testify, that never came in, but it was something I wondered about. Now, one of the most effective arguments I thought that Alan Jackson made was that the Commonwealth may have been dishonest with the jury. This is really deadly. One of the worst things that can happen to you in a trial is for you to lose credibility with the jury as the attorney or as representing your party, because if that happens, all of the evidence that you got gathered up and that you're presenting, they don't know whether to trust that because they don't know whether you tell them the truth anymore. So that's the worst thing that can happen. And they came up with really a list of things where they may have been mistakes, they may have been intentional, but it certainly did look bad when the entire list was put together. Now, one of them was the story about Kelly Devers, the police officer, the Canton police officer, who had a very specific story that she told the FBI when she was interviewed. Remember, this jury doesn't know technically it was the FBI. They just know it was some other agency. She told them a very specific story, which she walked back with both with the FBI and also here at the trial.
As we've just seen, you heard evidence that Higgins and Chief of Police Kenny Berkowitz, also good friends, were in the Sallyport together with the SUV for a, quote, wildly long time. Kelly Dever, another Boston cop, told you that. She also told law enforcement agents that she found it, quote, weird that Higgins could have access to that very sensitive evidence. These are all incredible details to tell law enforcement. She couldn't have been clearer. She couldn't have been more specific. But then she's put on a witness list and she's subpoenaed by the defense. Oh boy. Then this rookie cop was called up to the police commissioner's office, the same commissioner that was the boss of Brian Albert. They have a meeting, a private meeting, and he says, wink, wink, nod, nod, we support you, Officer Dever. All you need to.
So that wasn't the only issue by any stretch. We've already named several here, but also there was that inverted Sallyport video from trial number 1. There was the suggestion that x-rays weren't taken of John O'Keefe's arm. So who knew? Maybe he actually had a broken arm, and then it turned out there were x-rays taken. And then there was Brennan's question to the expert witness about the holes in the back of the shirt that it turns out were made by the crime lab. Now, the judge instructed the jury that here's the thing, this was Mr. Brennan made a mistake, and these were actually made by the crime lab. But it was an embarrassment. And so it was something that the jury will have this list of things, and the defense is saying, once you believe these, you can't trust the Commonwealth anymore. And then there was an absolutely rousing closing. It was just fantastic.
No, the Commonwealth failed. Do not let the Commonwealth get away with this. Could you ever say to yourself, this is justice? The fact is there was no collision. A car did not kill John O'Keefe. So I ask you, let your voice be heard, not in whispers, but in truth. Let the community feel through your verdict that justice cannot be bent and that it will not be buried. Find Karen Reed, not guilty, not guilty, not guilty.
Just absolutely excellent, I thought. Absolutely fantastic. And at that point, I was thinking to myself, what is Hank Brennan going to do? Is he going to have anything to say? This is so powerful. Is he going to be able to step up now that we have heard that sort of impactful closing argument from the defense? And the answer was yes, he could. He did a really great job as well. And so the jury has a lot to think about. There were excellent arguments on both sides. I do want to say thank you to some of the people in the super chat. Mama Pinks is saying that her father-in-law has been watching along. She didn't even know that. She insists she did not persuade him, and he is fully on the not guilty team. Tanya thinks AJ is a bad actor. There was one point where he said something like, what was that word? And he fully remembered what that word was. False memory. That was the description that Devers had of what she had originally told the FBI and that she walked back. It was a, quote, false memory. But anyway, that was pretty funny. And Kit Kat is on the other end saying that Proctor had nothing to do with some of this critical information, particularly what you are about to see, which is Karen Reed's own words, and that were so effective. And Bethany is gifting 5 lawyerly memberships. Thank you, everybody. All right, so let's take a listen. So the start of the Commonwealth's argument was, look what Karen Reed did. Look what she could have done to help her boyfriend, and look how little she cared.
There's only one person in this entire planet who could help him that morning, to give him a chance. Maybe it was a 33% chance if he met the Isaac Wolf of the world. But to give him a chance. And that one person who could help him that morning was this defendant right here, Karen Reed. And she made a decision. In her Lexus with the shattered taillight, debris field all over the front yard, and John O'Keefe lying helpless like a child on the front yard. She made a choice. She didn't call 911. She didn't run to his aid. She didn't knock on a door. She made a decision about herself. In her Lexus, she drove away. She was drunk. She hit him, and she left him to die. She was drunk. She hit him, and she left him to die.
Notice the repetition. They both did it. It was very effective on both sides. Now, according to testing done the next day at the hospital, Karen Reed's blood alcohol level at that time was 0.08. And the Commonwealth used expert witnesses to say, okay, well, if she's already legally intoxicated at 9 the next morning, she clearly was legally intoxicated 9 hours before when she was dropping John O'Keefe off. So they extrapolated and came up with a figure saying she was 2 to 3 times beyond the legal level that was permitted. She said, and Brennan argued, look, they were fighting. They've been fighting all week. And then how do we know that she was drinking? How do we know they were fighting? He's going to give us some of her words, starting with how we know that she was drinking. This is what he
If we listen
played.
to slide 2, she'll tell you exactly what she thinks about that claim.
My alcohol intake's probably about 5 or 6 or 4. The drinks that they reportedly at McCarthy's, which is where I consumed most of the alcohol, was the weakest at the time. It tasted just like old soda water with lime.
Slide 3, please.
I wouldn't have gotten on the expressway. I wouldn't have gotten on the expressway at 12:15 or 20. I mean, it was quiet. The roads were very quiet. You can see on the videos. And I was going, when I packed the drinks, I drive, I always drive extra slow. And I know my alerts aren't as sharp as they should be. But I shouldn't have been driving.
So there's about
So she actually stated in those clips, those are clips from media interviews that she did. And Brennan used them incredibly effectively during the trial. And what she says in there is that, because it's a little hard to hear, but she talks about how they were serving really weak drinks, and she probably had 5 or 6 or 4, some number, and that she wouldn't have driven on the expressway. She probably wouldn't have been safe to do that. Her alerts aren't as sharp as they should be. And so I shouldn't be driving. Those were her words. She didn't use the word safe, I don't think. So, and as I said, they were fighting. Their last minutes were, and in fact, his last minutes of life were with them fighting. That was one of his arguments. And he played this.
2 minutes left for John O'Keefe. And what are they doing in those 2 minutes? What are the last 2 minutes of his life that he can remember that would be open to him? They're arguing. They're arguing. They're arguing. And we know they're arguing because Miss Reed tells us through first responder Becker. She was sad. Remember, he sees her in the back of the ambulance and he's trying to calm her down? She was sad because her last moments were arguing. They're in an argument. That's why they're not going in the house. He has his phone.
So the cell phone data also confirms, according to Hank Brennan, that John O'Keefe never went into the house. It shows he stayed near the flagpole. Brennan says, why? Because he was hit by her car. And also his cell phone gets colder and then stops getting colder, slows down in terms of getting colder because it's under his body. And then when they roll him over, it gets exposed to the cold and it gets cold again. But the fact that it consistently lowers in a line going downward means he never went inside the house. If he had gone inside the house, there would have been an uptick, it would have warmed up and then gotten colder again. But that's not how it happened. So he gave this, I think, very powerful description of how it happens. You may disagree with it, but I think it was a powerful description.
When he looks down, 12:32:09, he sees a text message from his friend, John McCabe. And he looks at the text message, and he closes it. And then it happens. We know from the uncontroverted data from that black box, we know that Karen Reed, after he gets out of the car, drives away. She drives for at least 33 feet away from him. He's back near the flagpole, she's gone. It's over. Whatever argument is over. Whatever anger and flame has been dispassioned, she's moved on. He's separate from her. He's safe. And then she makes a decision. That's what this case is about. Then she makes a decision. She could have driven home. She could have broken up with him. They could have talked about it the next day. Or like knocking on the door, like Kaylee said, getting the last word. She doesn't drive away. She takes that 6,000-pound Lexus and she makes a decision. And the decision is that she steps on the gas after banging it into reverse.
So he's going wholeheartedly on the idea that she intended to back up straight toward him, not to hit him. He's going to argue that in just a minute, but intended that she intended to put it in reverse and head straight back toward John O'Keefe. But he is going to make the legal distinction that's so important for the state, because that's a pretty high burden of proof to say she intentionally hit him. He's going to say that's not what we have to prove because we're only going for second-degree murder. Here's what he says.
We're not trying to prove that she intended to hit him. We're not. What we are obligated to prove, and what we have proven from the evidence in this case for second-degree murder, is that she intended an act, and that is putting the car into reverse and heading back towards John O'Keefe. She intended that act. The question then becomes, did her conduct create a clear, plain, strong likelihood of death? Late at night, dark, beginning to snow, under the influence of alcohol, knowing where she stopped and left him after an argument, heading back in reverse to the exact spot or right near where she left him at over 24 miles per hour, accelerating at over 75%. You need to ask yourself, are you convinced if somebody does that, does that create a plain and strong likelihood of death? And if there's no doubt in your mind that she intended to hit that accelerator in reverse, and that conduct will create a clear and plain likelihood of death, then she is guilty of that crime.
Now, he gives the analogy to the jury of a person throwing a boulder off a bridge. And they may not be thinking to themselves, oh, I want to kill someone, but they're thinking, oh, this is going to be funny. This is going to bother people. And then it actually happens to kill somebody. And so he's making that analogy, saying that's the kind of thing we're talking about here. He also talked about this for count 3. We're going to look at the counts.
Was she under the influence of alcohol? And then secondly, did she operate her Lexus wantonly and recklessly in a way that would very likely result in serious injury? When you're under the influence of alcohol and you drive a 6,000-pound Lexus in the heat of the moment at the direction of where somebody is, whether you intend to hit them or not, I submit to you that is wanton, it is reckless. And any reasonable person would think it's very likely that serious injury would result. But for the third charge, Commonwealth has to prove beyond reasonable doubt she knew she hit him. We weren't there, but there was an eyewitness, there was a guide, and that eyewitness tells us that she knew. And that eyewitness is Karen Reed herself. She tells you that she knew. Could we have slide 8, please?
Could I have hit him? Did I hit him?
How could that have been? I mean,
I don't know what that could have been. It was howling wind. I had YouTube blasting on the stereo, and I thought, did he somehow try to flag me down, which was the reaction I was hoping to garner as I slowly pulled away from the house. Did he come up and maybe trip or bend over to pick up his cell phone, and I bent over his foot and then passed out drunk? I mean, I didn't think I hit him, but could I have clipped him?
When she left Fairview and left John behind. She didn't think he was mortally wounded, but she knew she hit him. She knew she hit him. And so when she made her way back home, not only did she leave debris field all over the front lawn, but she took evidence with her too. Hair, DNA on the taillight.
Now, I mentioned that he really leaned into the idea that she was angry with John O'Keefe, that they had been arguing all day, and he played those really angry text messages. I pulled at least one or two of them out just because they have a lot of words you have to bleep out. But she sent him some angry text messages. Now, the defense says these text messages are sent because she dropped him off and he was supposed to come right back out. He didn't. And she finally left saying, where are you? Why did you not show up? The Commonwealth says, no, she's really angry with him.
53 phone calls that night. 53 phone calls. Not one to 911. Not one to Jen McCabe, please go outside and try to help. Not one to a hospital. He's not in a fight. If he's in a fight, his cell phone would be moving. There would be healthcare data. There'd be steps. If he got into the house in 20 seconds and his cell phone is found under his body the next day, then how would he get back outside? There would be more steps because his phone is working. The data is the data. Poison number.
Now, one thing I thought was really intriguing, he played a message from Karen Reed to John O'Keefe, and I left this one in. I bleeped out some words, but he gave it a really ominous twist that I had never really thought of before. So here's how it played out in court today.
Listen to this.
John, I'm the only kid. Nobody knows what her.
Did you hear that? Nobody knows where you are. It is 12:59. John O'Keefe has been on that lawn for about 27 minutes. She hasn't called anybody else, hasn't spoken, has no information. Nobody's called her. You'll see her phone records. And she says, nobody knows where you are? She knows. She knows. Why is she asking nobody knows where you are? She is starting to get panicked because she knows she hit him. Not suggesting she meant to kill him or for him to die, but she knows she hit him and now he's not responding and she's getting nervous and she's getting anxious and she's leaving call after call after call. He's not answering and we know what's happening at this point. Panic, drunken denial, it's setting in.
So to me, the highlight of his closing statement is the part I'm about to play for you. And it was a highlight to me because he did just what I showed you Jackson did so effectively. He took some facts that we knew about and he put them together in a story that helped the Commonwealth side, just as Alan Jackson did the same thing to help the defense side. And they weren't necessarily the way you might have thought about it before. So I thought it was pretty effective. Here's what he said.
And when she wakes up, she doesn't call Jen McCabe and say, where's John? She doesn't call Brian Higgins. Has his number, has been texting with him. Hey, was John at a party with you? Did you see John tonight? She knows exactly where she is and she's frantic. So she wakes up Kaylee, that young girl at the time, and she says, she's panicked, she can't understand what she's saying. Call Jen McCabe, call Jen McCabe. Why is she calling Jen McCabe? She calls Jen McCabe. You know what she doesn't say when she calls Jen McCabe? When did he leave the house? What happened last night? No. She calls and says, I left him at the waterfall. I left him at the waterfall. See, now it's gone from panicked to self-preservation. I left him at the waterfall. And Jen says, left him at the waterfall? We saw you in front of the house. Click. Hangs up. Hangs up. So then she calls someone that she doesn't know very well. She calls Kerry Roberts. But now she has to pivot because someone has seen her in the exact spot that John will be found soon. Whether she's the first one there or somebody else, John will be found. Maybe Lucky missed him. It's a snowstorm. You can't see. But someone's going to find him at some point. So she calls Kerry Roberts. It's no longer she left him at the waterfall. She pivots. And she calls, Kerry. John's dead. I think he got hit by a plow. Why do you think she chose those words? Why did she choose those words? Because she knew that there was a collision with a large motor vehicle and she had to substitute her 6,000-pound Lexus for another big vehicle. I think he got hit by a plow.
So I thought that was pretty powerful argument, putting together a lot of the facts and putting them in a light favorable to the Commonwealth. He also talked about the fact that one thing we've heard about for years now, that Karen Reed knew just where to find the body. That's the argument the Commonwealth makes, that she knew where he was before the women in the car could see him. It's the middle of a blizzard. He's covered by snow. How, the Commonwealth asked, did she know that he was there? Now, of course, the defense says, well, she's just looking really hard and she happened to spot him first. But this is the argument that Hank Brennan made in closing.
Knows where to expect to find them because she knows where she left him. She tells us. Slide 13, please.
Driving gents in the passenger seat. And I described this to everyone, so you probably heard this before, but John looked like a buffalo on the prairie. It was just a lawn in a heat that it wasn't a bush or a hydrant or a dog. It was a weird shaped lump at that time in those elements. And I was looking to find him on the side of the road. I was expecting I'd find him.
So why, the Commonwealth asked, was she expecting to find him on the side of the road? All she knew, the Commonwealth is arguing, was that he was supposed to be in the house at 34 Fairview and he didn't come home. Why didn't she just assume he slept there? Or even maybe he was having an affair, but what would make her think he's on the side of the road or that he'd been hit by a plow? And so that was the argument that the Commonwealth made, is that her words here don't go together with the idea that she had no idea. There were also the words that we've heard a lot about in the past about that she supposedly said to people at the scene. Now, the defense says, yeah, that didn't happen. These people have changed their stories. They added that she said, I hit him, I hit him, I hit him, after they knew the Commonwealth really needed her to have said that. Here is how Hank Brennan addressed that argument.
Thank you. And these people are making it up. Anybody that says anything adverse or inconsistent or inconvenient is a liar or a perjurer or in on a conspiracy. Or is it that these good people who went there for a total stranger to do their duty to help happen to remember that she admitted what she had done? I know that doesn't reconcile with the boogeyman Proctor and the bad government. I know it doesn't reconcile with no DNA on this piece or that piece. I know it doesn't reconcile with everybody setting up the girl. I know that doesn't reconcile. But the reality is, you have independent, core people who hear her say, I hit him, I hit him. And the attempt is to betray everybody as a liar. But you don't have to rely just on these good people, although you should. You should. You don't have to, because we have a guide, and it's Karen Reed. Slide 17.
So what was said was, did I hit him? I've always said I hit him, but did I really say it as many times as law enforcement's claiming I said it?
Can someone have a collision without lower body injuries?
So let me stop for just a minute. So he says, look, there's no grand conspiracy. This is all made up. And he made one last point that I wanted to show you, which is that it is possible for John O'Keefe to have been in a collision and not to have had lower body injuries. That's an argument the defense made, is look, he's got markings, scratches, punctures on his arm, and we believe those came from a dog. That's what the defense says. The prosecution, the Commonwealth, says it came from his elbow going into the taillight. They both had experts on that. I did a video on that about what ChatGPT thought, so check that out if you haven't seen it yet. But the defense said, well, what about the lower body? I mean, how do you get into a collision and have no broken bones except the back of your head, which presumptively didn't come from the car, probably came from the ground? Like, how did this happen? And he used the experiment, the testing that was done by the defense expert to argue that it is entirely possible.
Slide 19, please. You bet they can. We don't know if this is the body position. We don't know if this is the exact speed, but what it tells us, this is viable. Look at the debris field. Look at his turn. Remember his sneaker on that curve? They got lodged against the sneaker. Mr. O'Keefe then falls back, hits his head, counter coup, left to die.
Okay, let's go ahead and pull that out. I will remove that and make this bigger. Okay, so as I said, these were phenomenal. I mean, if you watched today, you saw some of the finest legal work I have seen. It was amazing, just absolutely amazing. I want to close out our poll. I've got another poll I want to do. I want to get your opinion on. Jackie P, thank you very much for gifting Lawyerly memberships. K-Can is talking about Allie McCabe. You know, K-Can, I'm feeling like if Allie acknowledged that the defense would have brought her, but I can't say for sure. I appreciate your letting us know. Okay, so let's go over and see what y'all have voted on the poll. Okay, so what do you think will matter to the jury? 43% of you say it's going to, I should end the poll. Okay. 43% of you say that it's the defense experts. Actually, it just switched to 42%. Okay. The poor investigation, 35% of you think that will matter. Clips of Karen, 18%. Witnesses at the scene, 2%. So you aren't really buying that. I hit him. At least you don't think it's going to be pivotal. You think it's going to be the defense experts and the poor investigation by the Commonwealth. Okay, thank you. I appreciate your thoughts on that. And I wanted to close that out because I want to ask you about what, if, especially if you got a chance to watch it, but now you've seen some clips, so you can give me your opinion. Who had the stronger closing argument? I am curious what you think about this. So your choices will be Commonwealth, or Karen Reed, the defense, or we'll just say, you know, too close to call, something where you can't really say. Okay, let's see what you think about that, and we will find out about that. All right, so I do want to answer some questions. If you would put question marks at the beginning of your question, it'll help me spot it in the chat. Sometimes when it goes fast, I'm a little slow finding the questions in there. Okay, so I thought they were both truly excellent. I will say I thought they were phenomenal. Both were. The defense was amazing, and I thought that the Commonwealth just put together facts really effectively, really, really well. All right, let's see what RN2, oh, I know what it was. I kept thinking there was something we want to talk about, the jury verdict form. Mama Pinks asked me about that before we got started. So RN2 Moms says, if convicted, what would you say are the best appellate issues? I think one of the things about this case is they planned this from the beginning, and that's exactly how it should be. The biggest appellate issues are going to revolve around what got included and what didn't, most probably, what evidence was allowed in and what evidence was prevented. The judge did end up allowing a lot of the evidence. There were some things about third-party culprits that she kept out. There were some, for example, the FBI investigation, the fact that the ARCA witnesses stated that could have stated that they were hired by the federal government, those sorts of things. So it's a little hard to know. And I do want to look at the jury verdict form because that might be an issue. Oh, there we go. We're going to add that to the stage, and I'm going to be, and so I do want to talk about that, the verdict form. The verdict form is divided into the 3 counts that she's charged with. I'm going to blow this up and make it pretty big. And so this is an answer in part to your question. Number 1 is, oh, actually, I'm on number 3. Let's go back to page 1. Okay, page 1 is murder in the second degree. And it's fairly clear. In the above entitled case, we, the jury, say that the defendant is, number 1, not guilty. And there's a little blank there where they could check. And number 2, guilty of offenses charged, murder in the second degree. And the way the verdict forms are pretty much always done, not guilty comes first, so that there's not a bias for the jury to just check the first one. Although, what jury would do that? That's truly even an appalling thought. I'm kind of busy. It's a murder case, whatever. I'm just going to check the first one. What on earth? But fairly clear. we're going to skip the second one, which, as you can see, is a lot more complex. And we're going to go to the third one, leaving the scene of an accident resulting in death. In the above entitled case, we, the jury, say that the defendant is 1, not guilty, 2, guilty of offenses charged, and they specifically list which one it is. Fairly clear, right? Not guilty, guilty, you can kind of see that. So the question was, what about this one? It is obviously more complex. In the above entitled case, we, the jury, say that the defendant is, and the first choice is not guilty of the offense charged or any lesser included offense. And then they're going to list the offenses charged, which is manslaughter while operating a motor vehicle under the influence of liquor. And then they're going to go with the lesser included offense of involuntary manslaughter and the lesser included offense of motor vehicle homicide. And below that, number 5, lesser included offense operating under the influence of liquor. So each of those is a possible verdict. Not all of them, it should be that they select one of these. And not guilty is given as the first choice. I can tell about all right. So the question was, should not guilty be under each and every one of these offenses or ahead of them? Should it be not guilty, guilty of manslaughter while operating a motor vehicle under the influence of liquor, and then another not guilty, and then guilty of lesser included offense, and same for number 4 and number 5. Goodness. So, and in this case, as I look at this, anything this wordy can obviously be confusing to a jury. It's a lot of text here. And we ran into trouble on this very count last time, although it wasn't technically this count that was the problem. It's that the jury had agreed apparently on the other 2 counts, but they were stuck on this one. They didn't agree. So in this particular case, Mama Paints was wondering, should there be a not guilty below each or in front of each guilty? And it might be clearer to do that, like you're deciding this. But I think one of the things they wanted to emphasize to the jury is you're only going to pick one of these. You're not going to pick, oh, well, guilty of this and of this and of this. So they're trying to get them to pick one. It would, I think, anyway, I think it'd be better if they said select one. But it's not guilty of the offense charged or any lesser included offense. So will the jury get confused? Maybe. I think they are going to be completely safe on appeal here because of the fact that they do have the or any lesser included offense. I think the jury will probably figure it out, but I'm no lie, it's kind of complicated. All right, so let's see what some of the questions are. So let's get back to that. Do you think that Karen found John before Cameron? Do you think Cameron found John before she called? There was I think I see what you're asking me. It is BK Linty. There was a comment today from Brennan about a 28-minute gap where Karen Reed calls Jennifer McCabe, calls Carrie Roberts, and then there's this 28-minute gap before she shows up at Jennifer McCabe's house. Jennifer McCabe says, come on over and we'll go look for John O'Keefe. And it takes her 28 minutes when it's really only a 5-minute drive or a 10-minute drive. So where'd the extra time go? So the hint or suggestion was, what'd she do during that period of time? Did she maybe drive by 34 Fairview, see John lying there on the lawn and say, oh, okay, we got to deal with this. I'm going to have to come up with a story. Here's what I'm going to do. I'm going to go back with Jennifer and with Carrie. We're going to drive around and look for him, and then we'll pretend to all find them together. I won't tell them I've already been here. So that was the hint that he was giving. So I think that was the argument they were making. Yes. Michelle B is asking me, which witness or expert do you think was the most effective for each side? Wow, that is a big question. I think, let's see. who was really good. I felt like and this is so unusual, but I felt like the expert witnesses were real stars this time around. Typically, the expert witnesses are they matter. It's not that they don't matter, but it's so technical that I think a lot of times it's the fact witnesses, the scene witnesses. Those are the people who matter the most. And this time around, I felt like the expert witnesses were really, really important in this particular case. Sherry asks, explain why the defense did not bring Proctor, Higgins, Albert. Didn't they point a finger at them? Wouldn't it have helped to bring them? Sherry, that's a really good question. And I think until the last minute, they were probably debating it and talking, should we, shouldn't we? I think that it was too risky. Proctor, Higgins, Albert all have really negative things to say, right? Higgins can, everything they have to say, especially for Proctor, would be negative, except the things that Karen Read feels like she mostly already got in. She already got in that there were these text messages between Brian Higgins and Karen, and she got in the fact that he didn't turn over his phone. She got in the fact that he motioned to John O'Keefe to come when they were going to the party afterwards. So all of those sorts of facts came in, and they would have had to have had these witnesses on direct examination unless they were deemed to be hostile witnesses. And so I think they just thought, are we really going to be able to get more from them? Or are we going to end up losing some points? Because we already have the good stuff in, and there's stuff they can say, like Proctor can say, well, here's how I collected this, and I was very careful. Right now, Proctor is just the bad guy, and there's nothing that has suggested, other than Buchanan said, yeah, well, I thought he did a good job. But other than that, there's really not a lot to support that. And so I think that may be part of it. Do jurors, Bonbon asks, sometimes get stuck on a single piece of evidence, like the sweatshirt holes, rendering Hank Brennan deceitful and not believing Hank Brennan at all? 100%, Bonbon. That is such an issue, is that I do think a lot of times juries get fixated on something really particular and it's not necessarily the big picture in the case. Yes, something like that could be all important. We'll find out, hopefully, when they come back out, what the things that mattered to them were. But yes, you're absolutely right. That definitely can happen. Oh, y'all all put that in before I even ask for questions, because here's Mama Pink's notice that we should be doing this, that you should be putting questions in. Megan, in your experience, do you feel juries usually get it right? That is such a big question, Megan. I think the answer is generally yes. I think juries really want to make good decisions. I think they take it seriously. I suppose there's been some jury somewhere that said, we'll check the first box, but I don't think that's very common. I think most juries really want to do the right thing, and they try their best to do that, and they try to listen to all the evidence. That's for the most part. It does depend not just on the jury, but on the individuals on the jury. I think that the task is becoming more difficult for juries as scientific evidence becomes more important, and we're asking more and more of them to understand the DNA, to understand the cell phone evidence, the data, the text stream. I mean, all of that is new. And I think that it's more difficult now. But I do think for the most part, they do get it right. And let me say this too. One solution sometimes proposed is that we would have judges do this. I'm not really sure. My views on this are changing. I would say they're definitely in flux. As I watch this, as I watch the struggle to relate scientific evidence and so forth. But I do think this, all systems are flawed. Every jury comes with nothing but people on it. Every panel of judges comes with nothing but people on it. So there is no perfect system. Everybody is subject to making mistakes, is subject to biases and to decisions influenced by particular facts that aren't included. So I do think that there are flaws no matter who makes a decision. So Kevin says, the biggest appellate for me was the sweatshirt hole in the DNA dog no trays. Cumulative for me. I'm not sure about the trays part, but the DNA, yeah. So thank you. I appreciate that. Those are definitely going, I mean, all of these issues are going to be important if it gets around to an appeal, assuming, of course, that we actually get a jury verdict. Let's go over and see what your answers have been. All right. So who had the stronger closing argument? I'm going to end the poll in just like 10 seconds. So lock your votes in super quick. And as we're talking, and then I'm going to look for some more questions. All right. So we've ended the poll. 75% of you think Karen Read had the stronger closing argument by Alan Jackson, and it was phenomenal. It was absolutely phenomenal. The Commonwealth, 15% of you felt that was stronger, and Hank Brennan was very, very strong. I thought his was excellent. And then too close to call is 9%. That's kind of interesting to me because I think that those reflect sort of more nuanced numbers than I've seen in the past. So I think that's really interesting. So let's go ahead, and I want to put up one more poll before we, and while I'm answering a few last questions, I am curious about which surprised you more, because I felt like the closing arguments were somewhat of a surprise. And I am curious what you thought. Which surprised you more? Was it the Commonwealth? Was it Karen Read? Or you can say, well, let's just go with neither. Neither one really was surprising to you. I won't say my answer till we get to the end, but okay. Let's head over here. I'm looking for question marks again. Does Commonwealth have to prove impact or prove it was possible? Well, they have to prove that there was a car involved. If Karen Read didn't hit him with her car, then Karen Read wins. She is not guilty because she's charged with hitting John O'Keefe with her car. So do they have to prove impact? There has to be something with her car that does something to John O'Keefe. So I would say that is impact of some type. I don't see there's any getting around that. They have to prove that much. Cheryl wants to know, why was the jury not sequestered? In this particular case, it might have been a really good idea to do, especially given that they have an entire weekend now to wait, and it's a smaller community. But the reasons typically are inconvenience to the jury, harder to get a jury because who wants to be locked up for a while? And you have family and commitments that you need to do. And then also it's really expensive. That bill has to be footed by the Commonwealth, by the local community, and it's expensive. So those are kind of the reasons. Why was the Commonwealth the last to present? Charlie asked. The way they explained it's done is that the defense goes first and the Commonwealth, which bears the burden of proof, goes last. Now, a lot of times, and we saw in Lori Vallow Daybell in the closing, the Commonwealth or the state is allowed to split the argument. So they do a little bit at the beginning, then in the middle, you see the defense, and then afterwards, you see more from the Commonwealth. Marissa asks, if Karen didn't call Carrie and Jen and find the body, what do you think would have happened? Would she have been charged? I don't know. That's really hard to answer. I would think yes. And here's why I think that, because she was by the flagpole, right? And Jen says, I saw her by the flagpole, but there wouldn't have been the I hit him. I guess they would have gone over and seen the shattered taillight. I mean, I'm assuming the Commonwealth theory is correct. I don't know. Super interesting question. All right. Laura Lou has been a member for a month. That's wonderful. Thank you for being a member. Jezebel, I appreciate that very much. And Gingy Probs has been a member for 13 months. It was a pleasure to watch Good Lawyering. Did I say thank you to Jackie P? I can't remember. She is a large donor of Lawyerly memberships, and I appreciate that. All right, we'll do a question or two more. I do need to tell y'all that next week I will be gone and I will not be actually on. Although I'll probably go live when there's a verdict, because you can bet I'm going to be watching for that, like all of you. But I am not going to be doing my regular live streams next week. I'm going to be spending time with family. I'm very excited about that, especially some little people. All right. Karen constantly whispering in Jackson's ear during the Commonwealths. Carolyn asks about that. I didn't spot that. It certainly can be annoying. One of the things that the jurors mentioned after the first trial was they felt Karen was a little too expressive and that they felt like she did too much during the trial. So I would guess that they've really suggested to Karen, and she's concluded that she needs to do less of that. But I don't know if she's successfully done that. That just may be her kind of personality. All right, we're Sky Goddess. What are your thoughts about Bev picking the four-person? I've never seen that. Murdoch, that's the only time I've seen it before, especially that she did it before picking alternates. Oh, did she? Did she? Now, isn't that intriguing? That is super, super intriguing. Okay. All right. Well, I don't know. That is really interesting. I didn't know about that. I'm going to have to go back and look at that. Super interesting point. All right. So we'll end the last poll, which was which surprised you more? And neither is the overwhelming answer. 50% of you were pretty much expecting what you got in closing argument. 27% thought the Commonwealth and 22% thought Karen Read. I was really surprised by the Commonwealth. I thought they really brought it in a way that frankly surprised me. I think I was already expecting that from the defense. I pretty much figured it was going to be amazing, and it surpassed last trial, and that was phenomenal at the time. So it was even better than that. It was truly a remarkable closing argument. Really, really well done. All right. Well, I will see you all a week from now, except we'll probably go live when there's a verdict. So I look forward to talking to y'all about. I don't think no one where I will be like wanting to talk to me about it. I'll have to go live just so I can talk to you about it and see what you think. So, all right. Well, I will see you a week from now and sometime next week.